In light of the multiple requests we've received in this regard and our commitment to create well-researched videos, we are making this presentation on whether tenants may suspend payments of rent in lieu of the COVID-19 induced lockdown. This question was recently considered by the High Court of Delhi in Ramanand versus Dr. Girish Soni. The court held that while there cannot be any standard rule in this regard, there are certain broad parameters that must be considered. The reasoning behind this was that every relationship between a tenant and a landlord is structured differently. Some might be oral tenancies, which last less than a year, while some might be elaborate lease agreements with or without force majeure clauses, while some might also include profit and revenue sharing arrangements. In this regard, the first section of law that the court considered was Section 32 of the Indian Contract Act, which provides for enforcement of contingent agreements. The court in this regard considered the Energy Watchdog versus CERC case from 2017, wherein the Supreme Court held that a force majeure clause, if at all one exists, must be examined in light of Section 32 of the Indian Contract Act, wherein the force majeure event must be examined as a contingent event, the happening of which might lead a tenant or one of the parties to claim that the contract has become void. The CERC judgment, or the Energy Watchdog judgment, further opines that express provisions of the contract must be examined, and they cannot be ignored in light of vague pleas of equity. There are certain risks that are inherent in every contract, and the risks associated with each party must be borne by those parties. Furthermore, mere difficulty in performing a particular part of the contract would not lead to its frustration. This is in line with the old contract law judgments, which include Panna Lal as well as Alopi Prasad's case. Now, whether or not there is a force majeure clause, Section 56 may be invoked independent of that. Section 56 of the Indian Contract Act provides for frustration of contracts. The doctrine of frustration of contracts states that when a particular performance of the contract becomes impossible, the contract can be treated as void. That is, when an obligation by one party cannot be performed, the party can claim that the contract has become void. Now, the application of Section 56 to lease agreements was considered by the Supreme Court in 1968 in Raja Dhruv Devchand versus Raja Harmohinder Singh, wherein the court was dealing with a question where it was not possible for one of the parties to cultivate the land owing to partition. The land was obviously leased, and the relief prayed for was for refund or rebate of the rent. The court held that Section 56 of frustration of contract could not apply to lease agreements. In paragraph 9 of the judgment, the court differentiated between executory contracts, that is, those contracts which have to be performed, versus completed conveyances, that is, a completed contract by virtue of a transfer of a conveyance, which a lease is. Drawing back to the very basic principles of property law, a property is a bundle of rights, and a lease is a transfer of some of these rights, limited amount of these rights which may be vested with the tenant. And that transfer of that right in itself is a completed contract. This proposition was upheld by the court, and therefore the court held that Section 56 of the Doctrine of Frustration wouldn't apply to lease agreements. Furthermore, this proposition has been upheld in the Lakshmipati versus Nityanand Reddy, as well as by the Delhi High Court in the Leela Hotel Ventures case. Furthermore, the third tier of this argument, beyond Section 32 and Section 56 of the Indian Contract Act, is that of 108, Section 108 BE of the Transfer of Property Act, which provides for a particular lease being brought to an end or being held to be void in the instance of a fire, flood, tempest, invasion by an army, violence by a mob, or any other irresistible force which may render the said premises not habitable completely and permanently. Now, what is important to understand here, as the court has observed, as the Supreme Court has observed, in both the Lakshmipati Nityanand Reddy case, as well as in the Raja Dhruv Devchand case, that firstly, there has to be an express provision of such a clause in the agreement. And secondly, that there has to be a permanent destruction of the property in question. The law has been furthered in this question, wherein courts have held that even the destruction of the building by itself would not amount to a complete destruction of the subject matter of the lease agreement, because the land in question still remains. Without getting into the details of whether the building has been permanently damaged or not, the court, the Delhi High Court in Ramanand versus Girish Soni, finally concluded that COVID-19 and the lockdown as a result of it would not lead to an invocation of Section 108BE of the Transfer of Property Act. Even BL of Section 108 would not necessarily be applicable. Lastly, the court considered equitable considerations, and such relief could only be granted in two kinds of circumstances. The first being where the tenant had been completely dispossessed from the premises, and the second being where the tenant had only been provided with one part of the premises, where part payment of rent could be permissible. Considering these are not situations that arise as a result of corona or of the lockdown therein, rent, in the absence of a force majeure clause that explicitly provides for such a scenario, would be due and paid. Lastly, the court further elaborated upon certain factors which it considered in this case. And it is welcome that the court has differentiated between the different kinds of lease agreements, because this gives the necessary economic context to every agreement. The factors that the court has considered include, firstly, the nature of the property, which in this particular case was in a posh area in Luton's Delhi, Khan Market. The second was the financial and social status of the parties involved. The tenants in this case were running a showroom business and they owned another property in the neighboring area. The landlord was a dentist. Thirdly, the rent, or the amount of rent specifically, is an important consideration. Herein, even though the court had mandated a payment of Rs 3.5 lakhs per month in lieu of an interim relief provided to the tenant against whom a Section 14(1)(e) eviction had been passed, under the Delhi Rent Control Act was still not considered, even though substantial, was still not considered a high amount in comparison to the rent in the neighboring areas, which even if the court decided to disregard the lease agreement of the neighboring area, the court accepted that the rent in that particular area was amongst the highest in Asia. Other factors which the court considered included the fact that the tenants were still in possession, that there was no explicit clause in the contract, and that there was no specific regulation passed by the government to protect a certain class of tenants against not paying rent. Therefore, the court held that at best there could be postponement, but there could not be any refund or rebate of the rent in absence of a force majeure clause in a lease agreement. The postponement even, as the court held, could not be for extremely long amounts of time, but had to be covered in an adequate and short period. This brings us to an end on our presentation on this question of law. Please follow, share, subscribe, and like this video. And in the description of this video, we have provided links of other platforms where you may choose to follow the Indian Youth Economic Association for other such well-researched content, as well as papers on economic and commercial laws. We hope that you are safe and are following the safeguards which are necessary to protect against this virus. Thank you.